Today is January 23, 2026, and a brand new immigration law has officially taken effect in the United States. Guys, let me tell you, this news has already blown up the immigrant community. Whether you're a new immigrant who just got your green card or a long-term resident with over a decade of green card holding, everyone is scrambling to find out how this will affect them. If you have a green card yourself, or if you know someone who does, you can't afford to miss a single word of what I'm about to share. It directly impacts your status, travel, freedom, and even your entire path to citizenship. I'm not fear-mongering, and I'm not spreading unconfirmed rumors. This isn't a proposal being debated in Congress, nor is it an expert guess. It's a finalized law, and it takes effect much sooner than most people expect, so please sit tight and listen carefully. Understanding this new law could be the difference between protecting your green card and falling into immigration trouble. To all my new subscribers, welcome. I'm your go-to source for verified, no fluff, immigration updates, no fancy gimmicks, just straight facts. Before we dive into the specifics of this law, let me clarify some basic concepts to keep you from getting confused later. First, what we commonly call a green card is officially known as a lawful permanent resident, LPR. Card getting one grants you the right to live and work permanently in the U.S., making it one of the most valuable immigration status in the world. Herein, what many people don't realize, the green card comes with ongoing obligations, and these obligations can change with new laws. U.S. immigration policy is never set in stone. Congress, federal agencies like USCIS, U.S. Citizenship and Immigration Services, at DHS, Department of Homeland Security, as well as presidential executive orders, regularly update policies. Changes are minor procedural tweaks, but this new law, what we're talking about today, significant enough to require immediate action from millions of green card holders. There's no room for delay. You might be wondering, what makes this January 2026 law so special? Why is it causing such a stir? There are three core reasons. First, it completely overhauls the green card compliance requirements that have been in place for decades. Many actions that used to be no big deal can now trigger status reviews. Second, it introduces a series of new entry, exit verification procedures that directly affect international travel. So, if you've been following immigration policy trends in recent years, you'll notice that the 2026 U.S. immigration landscape is shifting toward modernization, stricter enforcement, and what policymakers call status integrity. This new law is a key part of that broader shift. D doesn't exist in a vacuum, but rather as a critical component of the overall immigration system reform. Let us start with the official name of the law, the 2026 Lawful Permanent Residence Integrity and Verification Act. Honestly, the original text is thick, obscure, and filled with legalese. Most people can make heads or tails of it, so I spent an entire day sorting through it, breaking it down into 4 major changes that directly affect green card holders. I walk you through each one with real-life examples to help you grasp the key points quickly. The first major change is a complete restructuring of eligibility and status rules for green card holders. Under the new law, all LPRs must verify their permanent resident status through a federal database every 24 months. This is a brand new requirement, something we've never had before. Think back to the old rules. As long as you updated your address with USCIS when you moved, you basically had no issues with your status. You only needed to submit additional documents if you were traveling abroad or applying for citizenship. But now, things are different. Moving forward, you receive notifications via both mail and email, requiring you to confirm core personal information, your current address, employment status, permanent residency. This verification process takes about 15 minutes to complete online, which is complicated, but failing to finish it within 60 days of receiving the notification will directly trigger a status review process, and resolving it afterward will be far more troublesome. Let me give you a realistic example to make this clearer. Suppose Maria got her green card in 2022, is from Mexico, and now works in the restaurant industry in California with her husband and child. Under the old policy, as long as she lived in the U.S. continuously and didn't break any laws, her green card status was secure. Aside from renewing her green card every 10 years, she barely had any interaction with the USCIS. But under the 2024-month verification notice in 2027, at that point, she must log into USCIS' new official portal, confirm that her address hasn't changed, that she still works at the restaurant, and that she hasn't been living abroad long-term, then submit the verification application. I need to emphasize this. This is not optional. It is a mandatory obligation for every green card holder, regardless of nationality, or, some of you might think it is just a 15-minute process. How could anyone forget? But the reality is, many elderly green card holders, Immigrants with limited English proficiency or those living in rural areas with poor internet access may miss the deadline because they can't operate the online system or because they don't see the notification, especially if it gets filtered into the spam folder. USCIS new portal is just launching, so it will most likely have system instability and unfriendly user interfaces, making it even harder for people unfamiliar with digital devices. This is a key concern for immigrant advocacy groups, which we discuss in more detail later. The second major change focuses on travel and re-entry, and this is the issue green card holders are most worried about, with the highest number of inquiries. The new law clearly states that any green card holder who spends more than 180 days outside the U.S. in a single 12-month period will be subject to enhanced screening upon re-entry. Now, don't panic. Enhanced screening doesn't mean you'll be denied entry automatically. Its core purpose is to make you prove that you haven't abandoned your U.S. permanent residency. But the entire process will be much more cumbersome and time-consuming than before. Specifically, enhanced screening means you'll be directed to a secondary inspection area where customs officers will ask you detailed questions focused on your ties to the U.S., such as whether you have a stable job in the U.S., real estate or a rental agreement, immediate family members residing here, or if you paid taxes on time. Additionally, entry processing time will be significantly longer. While others might get through customs in 30 minutes, you could be waiting for hours or even longer. Let me compare this to the old unwritten rules to see how big the change is in the past. There were no clear legal provisions, but there was an industry norm. Staying abroad for more than 6 months might lead to a few questions from customs. Staying over a year risked being deemed to have abandoned residency. The new law lowers this risk threshold to 6 months and codifies enhanced screening into law, turning it into a mandatory process, shifting from flexible enforcement to a rigid rule with no room for ambiguity. Let me give you another example. Raj is an Indian-American software engineer with a green card working at a tech company in Silicon Valley. His company plans to send him to their Bangalore office in India to support a project for 7 months under the old system. He might have only needed to bring his green card and an employer letter. When returning to the U.S. Customs, would have asked a couple of questions about the project and let him through smoothly. But under the new law, his 7-month stay abroad triggers enhanced screening, which requires him to prepare a complete set of supporting documents with no omissions. Specifically, he needs to bring an expatriation letter from his employer, clearly stating the duration of the assignment, job response is returned, a U.S. rental or property deed, his U.S. tax returns for the past 2 years, proof of his wife and children UN documents such as his children's school enrollment documents, and his wife from employment letter, and a round-trip flight itinerary to prove he has a clear plan to tour. Furthermore, if he knows in advance that he'll be away for more than 180 days, he needs to submit a special form before traveling. While the specific form number and submission process haven't been fully announced, USCIS has made it clear that advance notification will significantly reduce the risk of scrutiny. Even if you don't stay abroad for more than 180 days in a single trip within 12 months, frequent short trips with excessive cumulative time overseas or high travel frequency may also arouse customs suspicion that you've abandoned your residency, because the core of customs judgment is whether the U.S. is your primary place of residence. If your life focus is clearly overseas, even if each individual trip is less than 180 days, you may face additional scrutiny. For example, someone with a green card who lives in Canada all year round and only visits the U.S. occasionally faces extremely high risks under the new law. Additionally, this change will have a greater impact on green card holders who need to travel international trade, cross-border, consulting, or overseas project management. In the past, they could arrange business trip durations flexibly. Now they must strictly control the length of each trip abroad. Staying over 180 days requires preparing a large amount of documentation in advance, which undoubtedly increases work difficulty and time costs. Some companies have even started adjusting their expatriation policies, imposing strict duration limits on overseas trips for green card holders to avoid putting their employees at risk of status issues. The third major change is the introduction of targeted annual reporting requirements covering 3 categories of green card holders, so check if you fall into any of these. First, those who obtain green cards through employer sponsorship, what we call employment-based green card holders. Second, those who got their status through the EB-5 Immigrant in Vista program. Third, those with conditional permanent residency, such as those who obtained green cards through marriage and are in the 2-year conditional period. If you're in one of these groups, starting in 2026, you'll need to submit an additional brief annual report confirming your employment status, business activities for EB-5 investors, or marital status for marriage-based conditional residence. I need to stress this. This annual report is separate from your annual tax return and the 24-month status verification, an independent obligation. When promoting this provision, Congress clearly stated its purpose is to combat immigration fraud and ensure that green cards obtained through specific pathways are used as intended. For example, the EP5 program requires investors to invest a certain amount of capital and create a corresponding number of jobs. In the past, USCIS' supervision of this program was relatively loose. Some investors withdrew their funds and failed to create enough jobs after getting their green cards, yet still retained their status. The annual reporting system is designed to close this loophole, requiring IB5 holders to report fund usage, project operations, and the number of jobs created each year. Any violations detected may trigger status revocation proceedings for marriage-based, conditional green card holders. In the past, you only needed to submit Form I-751 before the end of the 2-year conditional period to prove the authenticity of your marriage. Now, the new annual reporting requirement means you must notify your USCIS whether you still live with your spouse, and if there have been any marital breakdowns or divorces. This undoubtedly increases the administrative burden for conditional green card holders, but from a policy perspective, it effectively reduces cases of marriage fraud for immigration purposes. However, therein a catch. For those whose marriages have genuinely broken down but don't qualify for exemptions, the annual report may expose problems in advance, putting their status at risk. For employment-based green card holders, especially those who got their green cards through categories like EB-PIN or E2DUBI, were no longer tied to your original employer after receiving the green card. Even changing jobs or being temporarily employed didn't affect your status. But now the annual employment reporting you to stay with your original employer, you need to prove that your employment status aligns with the professional background stated in your green card application. You can stop working entirely and remain unemployed long-term after getting the green card, as this may be considered abuse of green card status. The fourth major change has a significant impact on pending or future naturalization applications, something that even surprised many. Immigration and USCIS only examined your residency on a 5 years immediately before your application, or 3 years if you're married to a U.S. citizen, confirming that you met the continuous residence and physical presence requirements. The new law completely changes this rule, allowing USCIS to review your entire history as a permanent resident, not just the 5 or 3 years before applying. Let me translate that into plain language. Suppose you've had your green card for 8 years and are now applying for citizenship. Under the old policy, USCIS only looked at your residency records, travel history, and compliance over the past 5 years. But under the new law, USCIS will dig into all 8 years of your green card history. Even a long trip abroad, a delayed address update, or a missed declaration from 3 years after getting your green card could become a focus of the review, affecting the outcome of your naturalization application. This does not change the 5-year or 3-year residency requirement itself, but it drastically increases scrutiny. I've come across a real-life case in the making. A Chinese woman who had her green card for 6 years. 4 years ago, she made multiple trips between China and the U.S. to take care of her sick parents in China, including one 8-month stay at the time. She didn't know this would affect her future naturalization because under the old policy, only the 5 years before applying mattered. She about to submit her naturalization application, and the new law has taken effect. USCIS will review all 6 years of her records, and that 8-month trip will be a key focus. She needs to provide sufficient evidence to show that her long stay abroad was due to a family emergency, and that she never abandoned her U.S. residency, such as U.S. property deeds, bank account statements, tax records, and proof of social ties. Insufficient documentation could lead to a request for additional evidence, or even a denial of her naturalization application. The reason this change surprised immigration attorneys is that it breaks long-standing review practices and has an overly broad retrospective scope. Many green card holders may have minor imperfections in their past due to a lack of policy knowledge, issues that were irrelevant before, but could now become obstacles to citizenship under the new law. This is a reminder, from now on you must keep all documents related to your U.S. residency, employment, and travel safe. Even seemingly trivial records may prove invaluable in the future. Now that we've covered these 4 major changes, you can understand why this new law is causing such a stir. But let me clear up a misunderstanding first. As this law does not aim to strip green card holders of their status across the board. It wants to automatically revoke anyone's green card, create new deportation categories, or ban green card holders from traveling abroad. Its core is to add a series of new obligations and compliance requirements. The panic among many green card holders stems from the fact that these requirements are beyond their expectations, with insufficient preparation. Specifically, this shock comes from 3 main factors. First, a lack of widespread advance notice. While this bill was making its way through Congress, it received little mainstream media coverage, except for professional immigration attorneys and policy analysts. Most ordinary green card holders had no idea such a bill was in the works. It wasn't until January 23 when the law officially passed that news began to spread. Many people are hearing about these changes for the first time after the law took effect, with no buffer time to prepare. This sudden policy rollout has left many scrambling, especially those planning international travel or preparing naturalization applications, who have had to adjust their plans urgently. And the existence of retroactive review provisions. As we mentioned earlier, the new law allows USCIS to review a green card holder entire residency history. This means people who took long trips abroad or had minor compliance issues years ago, who thought those matters were behind them, may now face re-examination by USCIS due to the new law. For example, someone who stayed abroad for 10 months 5 years ago, who would have been fined for naturalization under the old policy as long as they were compliant in the subsequent 5 years, will now have that 10-month trip re-investigated by USCIS, requiring them to provide supporting documents. This undoubtedly brings uncertainty and risk to many. Third, the excessive new administrative burden. The 24-month status verification, annual reports for specific groups, and documentation requirements for trips over 180 days all demand significant time, energy, and effort from green card holders. For those with busy jobs, heavy family responsibilities, or limited familiarity with U.S. administrative process in English, this burden can be overwhelming, especially for elderly green card holders, many of whom can't even use SAPSICs or computers. Its online verification process is an insurmountable barrier. I want to address some common fears versus reality to ease your anxiety and help you understand the actual situation. First common fear: my green card will be taken away if I travel abroad. The reality is, you can still travel internationally normally, and the new law doesn't ban green card holders from leaving the U.S. It just requires more thorough documentation and awareness of your time abroad. As long as you can prove strong ties to the U.S. and no intent to abandon residency, you'll be fine. For example, if you have a stable job, property, and family in the U.S., pay taxes on time, and are only traveling abroad short-term for tourism, family visits, or work, if your stay is close to 180 days, you won't face risks. The real risk is for those who live abroad long-term, have almost no ties to the U.S., yet still hold a green card. Second fear: I'd be deported immediately if I miss the verification deadline. The reality is, missing the deadline to lead to immediate deportation. Sheen triggers a review process. ICE will contact you multiple times via mail and phone, giving you the chance to complete the verification. For example, if you missed the 60-day deadline because you were hospitalized and didn't see the notification, you can apply for an extension by providing hospital records and explaining the situation to USCIS. You won't lose your green card because of this. However, if you intentionally ignore multiple notifications and refuse to complete the verification, you'll face status freezes, interview requests, or even deportation proceedings. This is a gradual process, not an overnight consequence. Third fear: this law targets specific nationalities or ethnic groups like Chinese or Latino immigrants. I can clearly tell you, this law applies equally to all green card holders, regardless of country of origin or ethnicity. USCIS is prohibited by law from discriminating based on nationality, race, or religion in enforcement. If you encounter discriminatory treatment during entry or verification, keep detailed evidence, seek help from immigrant rights organizations, and even defend your rights through legal channels. To sum up, the core logic of this new law is strengthening accountability and documentation requirements. If you've been sincerely living and working in the U.S., maintaining strong ties and following existing immigration rules, this law will only bring minor administrative inconvenience, not a direct threat to your green card status. The biggest danger is ignorance of these new requirements, violating the law unknowingly and ending up in a status crisis. The law passed this morning. Immigration attorneys across the country have been interpreting the policy and providing guidance to clients. Sarah Mitchell, managing attorney at a prominent New York immigration law firm, stated, "This law represents the most significant change to green card holders' obligations in over 15 years. It completely transforms how green card holders interact with the immigration system. Our core advice to clients is document everything, keep all records proving your ties to the U.S. safe, and stop relying on the old unwritten rules. Now everything must be based on the new law and official guidelines." Our team has already started helping clients organize travel records and prepare verification documents, especially those with complex travel histories and naturalization plans. Rushing to develop response strategies. Policy analysts have mixed views on the law. The Migration Policies Institute pointed out that the law reflects a global trend in immigration policy, strengthened digital verification, and status monitoring. In fact, similar permanent resident verification systems have long been implemented in Canada, Australia, and many European countries. For example, Canada requires permanent residents to reside in the country for at least 2 years within every 5-year period, otherwise they may lose their status. Australia uses an online system to track permanent residents' residency status regular. The experiences of these countries provided some reference for the U.S. in enacting this new law. However, immigrant advocacy groups have expressed concerns about the law and potential negative impacts. They argue that it imposes a heavy burden on elderly green card holders, those with limited English and rural residents. Many elderly immigrants have worked manual labor all their lives, have no experience with online systems. Rural residents may face poor internet signals or no internet access at all, lacking even the basic means to log into the system. Additionally, for low-income families, the cost of hiring an immigration attorney to assist with these matters is a significant expense, potentially leaving them trapped in compliance difficulties due to inability to afford professional help. As a result, these organizations are calling on the government to provide better support services, such as multilingual hotlines, in-person assistance centers, and targeted guidance for vulnerable groups, ensuring every green card holder can adapt to the new policy smoothly. In response to these concerns, the U.S. Department of Homeland Security released an official statement this afternoon addressing key issues. First, a 24-month status verification system will be rolled out in phases over the next 6 months. Not fully launched at once, this gives USCIS time to optimize the system and green card holders time to adapt and prepare. Second, USCIS will provide multilingual support for the verification portal, covering major immigrant languages such as Spanish, Chinese, French, and Arabic. We'll also establish a dedicated phone assistance hotline for those without internet access or who can operate the online system. Additionally, the government will mail clear, simple instructions to every registered green card holder, preventing confusion from unreadable English guidelines. Most importantly, a 90-day grace period will be set for the first verification instead of the original 60 days, alleviating time pressure to some extent. USCIS also announced plans to launch a dedicated webcam hotline for this new law, centralizing answers to questions and providing operational guidance. Officials emphasize that their core goal is to promote compliance, not punish those who sincerely want to follow the rules. For green card holders who make good faith efforts, but commit minor violations due to objective reasons, USCIS will adopt flexible handling instead of one-size-fits. Several immigration law professors have pointed out an important distinction. This law does not change the nature of permanent residency. Green card holders still enjoy the same core rights as before, such as permanent U.S. residency, employment, and access to social benefits. What has changed is the administrative framework for maintaining and proving that status. In the past, it relied more on good faith. Now, it is based on institutional constraints, requiring green card holders to fulfill their obligations more proactively and standardizedly. Therefore, there is no need for excessive panic. As long as you adapt to the new requirements and prepare thoroughly, you can maintain your status smoothly. After covering so much theory and policy interpretation, let's move on to the most practical part. 6 things you should do right now. Each one is critical to your status security, so make sure to remember them and take action immediately. First, stay updated through official channels. This is the most crucial step. Be sure to bookmark the USCIS website, uscis.gov, and spend a few minutes browsing it daily. All policy updates, operational guidelines, and form downloads will be released here first. In addition, focus on the DHS website, dhs.gov, for macro immigration policy adjustments, and the U.S. Department of State travel website, travel.state.gov, for entry-exit guidance. A special reminder: don't rely solely on social media, forums, or word-of-mouth immigration. Misinformation, drafting on false information can have irreversible consequences. Also, sign up for a USCIS email alerts if you haven't already. USCIS will notify you of major green card or naturalization policy changes, as well as when your verification notice is about to be sent, ensuring you don't miss key information. Second, conduct a self-check of your current status and history. First, take out your green card and verify that the information is accurate, especially the expiration date and registered address. If you moved, update your address in the USCIS system immediately. This is the most basic yet easily overlooked step. Green cards are usually about to expire. My comrade, if it has less than 1 year left, start preparing for renewal in advance to avoid juggling both verification and renewal processes. Second, organize your international travel records. It is best to create a detailed travel log recording the departure, return date, duration, and purpose of all past international trips. Also sort out your passport entry, exit stamps, flight itineraries, and hotel bookings. This log will be invaluable for future re-entry and naturalization reviews, helping you quickly prove your travel history and avoid being unable to answer customs or USCIS questions due to fuzzy memories. Third, collect and organize relevant documents, creating a dedicated file. These documents are core proof of your ties to the U.S., your naturalization applications, entry screening, and naturalization applications. Specifically, organize the following: residency proof, rental agreements, mortgage statements, utility bills, covering the past 2 to 3 years is ideal. Financial proof, use bank statements, credit card bills, tax returns, proving stable financial activity and tax compliance in the U.S. Identification documents, use driver license, state ID, social security card. Employment proof, employment verification letter, pay stubs, W-2 forms. Use self-employed individuals prepare business licenses and financial statements. Family relationship proof, spouse, children IDs, birth certificates, marriage certificates. Prioritize this if your family members are U.S. citizens or green card holders. Additionally, prepare both physical and digital copies. Keep physical copies organized in a folder in a safe place, and back up digital copies to the cloud and an external hard drive, avoiding passivity due to document loss. Fourth, monitor your verification notice closely and set reminders according to DHS's statement. The first batch of verification notices will be sent within the next 6 months. Start checking your email daily. PEDS the spam folder. Avoid missing notifications at the same time. Ensure your registered mailing address and email with USCIS are up to date. Update them immediately if you move. Also, set a calendar reminder every 24 months starting from your green card approval date, whether on your phone or a paper calendar. A backup. For example, if you got your green card in May 2023, your first verification will be around May 2025. Setting advance reminders ensures you're prepared. Fifth, seek professional guidance for complex situations. Don't handle them alone. If your situation is special, consult an immigration attorney as soon as possible to avoid status risks due to misjudgment. Specifically, the following groups should prioritize legal advice: those with complex international travel histories, multiple long trips or high travel frequency, those planning to stay abroad for more than 6 months in the next 12 months, those submitting or preparing to submit naturalization applications, those with past immigration compliance issues, such as prior entry denial or delayed address updates. Those in the 3 categories requiring annual reports: employment-based, EB-5 investors, conditional residents. Note: the content shared today is for educational purposes only, not legal advice. Everyone's situation is unique. Attorneys can review your specific circumstances and provide personalized strategies to mitigate risks. Sixth, prepare thoroughly for future international travel. If you have travel plans, plan ahead to avoid last-minute issues. First, prepare documents based on your trip duration. If you expect to stay abroad for more than 180 days, learn about and submit the required form in advance, and prepare employer letters and proof of return plans to handle enhanced screening. Second, carry original copies and duplicates of core documents with you when traveling. Never put them in checked luggage for easy customs inspection. Additionally, allow extra time for entry, especially when returning from popular tourist destinations or immigrant origin countries, as enhanced screening may take longer. Choose an earlier flight to avoid missing subsequent plans due to customs delays. Finally, check the latest entry-exit policies on the USCIS and State Department travel websites before departure to ensure your trip complies with requirements. Now that we've covered what to do, let's discuss the consequences of non-compliance. Understanding the stakes helps you take this seriously without panicking. First, consequences of missing the 24-month verification. ICE will send a second reminder, then a third after multiple failed attempts to contact you. Your case will be placed under review, and USCIS may require an in-person interview to explain the situation. If you still can't prove compliance after the interview, you may receive a notice to appear, NDTA, for immigration court proceedings. In extreme cases of long-term non-cooperation, your green card may be revoked, but this primarily targets those intentionally evading verification with no reasonable explanation. As long as you show good faith in complying and provide supporting evidence, you rarely reach this point. Second, Consequences of insufficient documentation for long trips abroad. If you stay abroad for more than 180 days and lack adequate supporting documents upon re-entry, you may face prolonged secondary screening. Customs may ask you to sign Form I-407, voluntary abandonment of green card. You can refuse, but this will result in your case being referred to an immigration judge to determine if the judge rules against you, your green card will be revoked. You'll be ordered to leave the U.S., and future U.S. visa or immigration applications will be severely impacted. Third, consequences of failing to submit annual reports. For those required to file annual reports, late or false submissions can lead to delayed or denied naturalization applications. For EB-5 investors, false reporting of business activities or suspected investment fraud may trigger green card revocation proceedings and even legal sanctions. Additionally, long-term failure to file annual reports may affect future green card renewal and impurine verification. If you're found to have obtained a green card through fraudulent documents or forged evidence for verification or naturalization, you may face deportation and be barred from future USCIS. Extreme cases. You could face criminal penalties for immigration fraud, including fines or imprisonment. Furthermore, if your status is under review or you have unresolved compliance issues, you may be barred from re-entering the U.S. after international travel, detained at the port of entry pending case resolution, or denied future visa applications if your green card is revoked. There are also administrative consequences that, while not involving deportation, can disrupt daily life, employment verification issues, preventing employers from completing Form I-9, endangering your job, inability to renew your green card, leading to invalid status, denial of professional license, such as for doctors, lawyers, or engineers, requiring immigration status verification, difficulty accessing eligible social benefits such as healthcare, retirement benefits. But remember, these consequences target those who intentionally violate or evade obligations. For green card holders who sincerely want to comply but make minor mistakes due to objective reasons, USCIS provide sufficient leeway, respond promptly to notifications, correct for help when they incur. Has repeatedly emphasized that it does not aim to trap people or create gotcha situations. So wants compliance and will work with those trying to follow the rules. To truly understand this new law, we need to look at the broader context of U.S. immigration policy in 2026. Over the past few years, despite deep partisan divides on many immigration issues, both Democrats and Republicans have reached a rare consensus on immigration system. This modernization focuses on digitizing cumbersome paper-based processes, strengthening identity verification through technology to reduce fraud, enhancing accountability across all immigration categories, and addressing backlogs and processing delays. This new law is a key implementation step in this modernization. Isolated measure, but part of a series of immigration reforms. The current administration has prioritized stay-based in salary. Simply put, every immigration status should mean what it says. If you're a permanent resident, the U.S. should be your primary residence. If you're here on a work visa, you should be employed in the occupation specified. Isn't it just rhetoric? You backed by concrete data. DHS statistics from 2024 to 2025 show that approximately 12 to 15% when notifications were sent. These individuals either move without updating their address or have been living abroad long term, no longer residing in the U.S. Additionally, there are documented cases of people obtaining green cards through fraudulent marriages or misusing EB-5 funds, cases that the new annual reporting and verification requirements aim to root out. Looking ahead, this law is likely to reshape how green card holders manage their U.S. residency. For frequent international travelers, it may mean adjusting career plans or investing more time in documentation. For EB-5 investors, it will require greater transparency in their business operations and job creation efforts. For elderly or digitally disadvantaged green card holders, community stabilization. Let's take a moment to address a question I've gotten repeatedly in the comments. Will this law affect my family members who are applying for green cards? The short answer is no. This law focuses exclusively on existing green card holders, not applicants in the process of obtaining permanent residency. However, if you're sponsoring a family member for a green card, the new compliance requirements may indirectly impact you. For example, if you're required to submit annual reports as an employment-based or EB-5 holder, maintaining a clean compliance record will strengthen your sponsorship case, as USCIS will view you as a responsible permanent resident. Another key point. The new law includes a provision for periodic reviews and adjustments. Congress has mandated that DHS submit a report to Congress after 2 years by January 2028, evaluating the effectiveness of the law, including compliance rates, administrative costs, and impacts on vulnerable groups. This means the law is set in stone for certain provisions prove overly burdensome or ineffective. They could be revised. For example, if the 90-day grace period for verification is still insufficient for elderly immigrants, DHS may extend it based on feedback. This gives green card holders a voice. If you face hardships complying with the law, share your experience with immigrant advocacy groups who can relay these concerns to policymakers in the next few years. Now is the time to get your records in order. Compiling every document that proves your ties to the U.S. Utility bills and tax returns to family photos and community involvement records. Remember, USCIS will now review your entire green card history, so even a single gap in documentation could delay your application. If you're unsure whether a past trip or compliance issue might affect you, consult an immigration attorney immediately, waiting until you submit your Naturalization. I also want to highlight resources specifically for vulnerable groups, for elderly green card holders or those with limited English. USCIS multilingual hotline, available in Spanish, Chinese, Arabic, and French, will be staffed with representatives trained to walk you through the verification process step by step. Many local immigrant resource centers on the DHS website on assistance. You can find a list of approved centers on the DHS website for green card holders with disabilities that prevent them from using the online portal. USCIS will accept paper verification forms by mail, though processing times may be longer for EB-5 investors. The annual reporting requirement will involve submitting detailed financial statements, job creation reports, and proof that your investment remains in the approved project. It's critical to work closely with your project manager and immigration attorney to ensure these reports are accurate and submitted on time. Failing to do so could not only put your green card at risk, but also lead to fines or legal action from the Securities and Exchange Commission, SEC, which oversee EB-5 investments. Let me wrap this up with a final reality check. Navigating U.S. immigration policy has never been easy, and this new law adds another layer of complexity, but not insurmountable. The key is to stay informed, be proactive, and document everything. This law rewards responsibility. If you are genuinely committed to making the U.S. your home and following the rules, you'll have no issues complying with these new requirements. Before we end, don't forget to hit the subscribe button and turn on notifications. I'll be updating this channel regularly with new guidance as USCIS releases more details about the verification portal, annual report forms, and other implementation specifics. In the next video, I walk you through a step-by-step demo of the USCIS verification portal once it launches, so you can see exactly how to complete the process. If you have questions about your specific situation, whether you're a frequent traveler, an EB investor, or a conditional green card holder, leave a comment below. I'll answer as many as I can in future videos, and if you found this information helpful, share it with friends and family who have green cards. This is one video they can afford to miss. Remember, knowledge is your best defense when it comes to immigration policy. Stay informed, stay organized, and don't hesitate to seek professional help when you need it. Herein to navigating this new law smoothly and protecting your U.S. permanent residency. Thanks for watching, and I'll see you in the next video.